Good morning and welcome to the new episode of Dr. Lamba's Awakening Call. Indian political scene and the judicial scene are witnessing a turbulence, and that's about the colonial sedition law. Now, what is sedition law? What are its origins? What are the legal challenges? How have the other countries dealt with sedition? And when the highest court in the country directs the executive to reframe the law and holds all pending trials in abeyance, then there must be something which is agitating the mind of the people. After all, in a democracy, sedition is something which should be taken seriously, because if somebody is really a traitor to the country, he must not be allowed to express his opinion. And secondly, if sedition law is used only to suppress the voice of opposition, only to suppress the dissent, then of course this is something abominable and hateful. So the charges under section 124A of the Indian Penal Code deals with the offence of sedition, and the central government has committed to re-examine whether it should be there or not. And strangely, all political parties oppose sedition when they are in opposition. And as soon as they come in power, they are the biggest supporters of this act, saying that, look here, if this act is not there, the country would be in danger. This is typically like saying your religion is in danger, your nation is in danger, your country is in danger, and it's used to suppress people. But there are always cases when there are real cases of sedition. So the law, should it be abolished or not, is something to be seen. And most importantly, it should be there in some form or other, but the process of arrest, the process of prosecution should change. Here also, the central government initially defended the colonial provision, but then itself agreed to review it. Now, what is sedition? According to the Indian law, whosoever by word, either broken, spoken, or written, or by signs, or by visual representation, that's a cartoons, pictures, or otherwise brings or attempts to bring into hatred, or contempt, or excites or attempts to excite dissatisfaction towards the government established by law, will be punished by imprisonment for life, to which fine may be added. That this is opposes the government, not the country. Opposing the government should be no crime in a democracy, because until you oppose the government, you cannot force the government to listen to sin. And opposition does not mean violence. Opposition can be a civilized way of debate. So that means all debate is to be abolished simply because you are opposing the government. So this is something which is troubling the mind. Then there are three explanations to this provision. First is expressing dissatisfaction includes disloyalty and all feelings of enmity. Comments expressing disapproval of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred. And they do not constitute an offence under section 3. That's a saving grace. Comments towards expressing disapproval of the administration without exciting or attempting to excite hatred, contempt, are also permissible. So as it is, apparently, there is nothing wrong with it. Now, how did this law originate? But we say this law originated with Lord Macaulay, who drafted the Indian Penal Code and included the law of sedition in 1860. But are you aware that even before that, people who were guilty of treachery were hanged and killed? Of course, there was no codified laws at that time. Agree. But treachery, treason, betrayal of the country has always been considered to be the highest crimes. Curiously, when Lord Macaulay drafted the law, he did not include in 1816, but in 30 years after that, in 1890, this law was included as an offence, and there was Special Act 817, Special Act 17, which was passed by the British Parliament to include it as a crime. Now, punishment prescribed was transportation beyond the seas for the term of his or her natural life, and it was amended to life imprisonment in 1955, because those lands across the sea was a colonial thing. India doesn't have a colony. So the provision was extensively used to curb political dissent during independence movement. We know it. Till Gandhi and all the leaders were imprisoned and prosecuted under sedition, and they were also sentenced into exile into Andamans and other places, and Burma, Mandalay. The first person to be exiled was Ram Singh, Guru Ram Singh, who started the Nirankari movement. He was sent to Burma. And several pre-independence cases involving were against celebrated, as I said, Bal Gangadhar Tilak, Annie Besant, Muhammad Ali, Maulana Azad, Mahatma Gandhi. So it was during this time that there was an opposition to the law. And in the Queen Emperor versus Bal Gangadhar Tilak was the most outstanding case of that time, which excited the people. Why is this law? But the courts usually followed a literal translation that this approbation must be compatible with disposition to render obedience to the lawful authority of the government and support the lawful authority of the government against unlawful attempts. Now, lawful and unlawful, they are very ambiguous terms, and they change from time to time, from person to person. When I'm in power, I'll consider anybody saying I'm wrong is unlawful, which it's not. So when India became independent, the Constituent Assembly debated whether to include sedition as an exception to the fundamental rights of freedom and speech, and most of the members disagreed, and the word was not included in the document. Now, if the fundamental rights do not say that you have a freedom to speak except when you are being treacherous, then it should not be a crime. So there is a contradiction in the Constitution and the law. Then came the legal challenges to this law. And the first challenge was in 1950 itself. It was Ramesh Thapar versus State of Madras. And the Supreme Court said that the criticism of the government exciting bad feelings towards it is not a crime, and it cannot be used to put a person in jail. Justice Patanjali Shastri cited the Constituent Assembly, and this law was told that, well, look here, you can criticize the government, but if it's not creating violence, then it's perfectly okay, because it's not undermining the security of the country. After that, two high courts, Punjab and Haryana High Court in Tarachand versus State in 1951, and Allahabad High Court versus in Ram Nandan versus UP government in 1959. So in the course of 9 years, from 1950 to 1959, three high courts declared that the Section 124A was a tool of the colonial masters and should be declared unconstitutional. Now the matter went to the Supreme Court in 1962. It was Kedarnath versus State of Punjab, State of Bihar. And this judgment was very important because this was a constitution bench. of the Supreme Court out of the 5 judges, and they had to study all the 3 judgments of the High Court. And the court had that unless accompanied by open call of violence, criticism should not be called sedition. And it restricted sedition only to those activities which incited public disorder, a phrase of section 124 itself does not contain, but was incorporated into it by the court order. So there was a major change. Then the Constitution Bench also issued the guidelines, and there were 7 guidelines which clearly said that the critical speech cannot be termed as sedition. So in its guidelines using the new restrictive definition of sedition law, the court said that not all speech with dissatisfaction or hatred is sedition. Now, following this order, public disorder has been considered a necessary ingredient for the commission of sedition. Then came 1995. Things were going quietly. There was a case in Punjab, Balwant Singh versus State of Punjab. And then the court decided that the real intent should be seen, not exactly the words, but what's the real intention. Now here comes the subjective element. Real intention, you are not a psychiatrist, you cannot read the minds of the people. How can you say what's the real intent? And the person himself says it, or writes it, or there is some corroborative evidence. So the ruling in the Punjab, Balwant Singh versus State of Punjab, reiterated that the real intents must be taken into consideration before labeling it seditious. Now here the accuser raises the slogans Khalistan Zindabad, Raj Karega Khalsa, Hindustan or Punjab, Kade nahi chhadange. So that was the demand. But was it saying for violence? No. So the court said that they cannot be convicted. It is against the country, agreed, but they are saying, they are giving their opinion, so it's not a crime. This was the most sensible suggestion. Comes 2016, Arun Jaitley versus State of Uttar Pradesh. Now here there was very thing. Arun Jaitley was being prosecuted and he had criticized the judgment of the Supreme Court. And the court decided that so even the Supreme Court criticism is not sedition. It's an expression of opinion. It can be contempt of court, but it cannot be sedition. So the Kedarnath guidelines and the subsequent judgments in the Punjab High Court and the UP High Court were outstanding. And that should have been there. But then we saw a lot of things happen. Last year, more than 100 cases were registered against journalists, political opponents and others. What is the incidental misuse of the sedition law? That's for the court to decide. So the petitioners then went to the Supreme Court, and the Supreme Court was really aghast. And even some magistrates and judges said that this decision is wrong and it should be repealed. Now what's happening in other countries? In UK, England, where sedition law was very important because it was controlling all the colonies, it was repealed in 2009 under Section 73 of the Colonies and Justice Act. And it said that this has a chilling effect on the freedom of speech. So this act was repealed. In USA, sedition is a federal felony and under the Federal Criminal Code and is used against Reuters. Even you remember 2 years back when January 6th there were riots in Washington, the people have been arrested and are being prosecuted for sedition. So, but Australia repealed its sedition law in 2010. Last year, Singapore also repealed it. So there is a general consensus against repealing, but the condition being in India what they are, and the fact there are there people with an extra territorial loyalty, and they are paid agents of the foreign powers out to create problems in the country. I think the repeal should not be there. As a matter of fact, it should be a mandate to ensure that no injustice takes place, that the honest difference of opinion is respected and not deemed sedition. Sedition should be only when there is an armed conflict, when there is an armed insurrection, like it was in Khalistan, like it was in Bezos, or there is a danger of a civil war, or there is a revolt by the uniform, obviously, as it was in UP, when the army had to be called in and disarm the UP police. So with those restrictions, if common people, if political opponents are exempted from sedition law, and it's restricted to certain specific conditions, instead of leaving it in ambiguous terms, this shall meet the ends of justice. Thank you.